Thank you. Good evening. Tonight's Committee of Adjustment hearing is being held by video conference and live streamed video on the town's live stream webpage at oakville.ca. This is a hearing to consider applications for minor variance and consents held under the authority of the Planning Act. Please keep in mind the intent of this process is to review the application that's before the committee, listen to the evidence, and then make a decision. This process is not intended to be used to resolve any concerns or disputes that may exist between the town, individuals, or organizations. If a request for a deferral is made and the committee grants such a request, the applicant or authorized agent must contact the Secretary Treasurer to schedule a new hearing date. In order to conduct an effective and efficient electronic hearing, we have adopted the following process. If you are watching the live stream of this hearing on oakville.ca, and if you wish to speak to an item on the agenda, please call 905-815-6095. Again, the number is 905-815-6095. The phone number is also posted on the live stream page at oakville.ca. Staff will be standing by to take your call. You will have to state your full name and address for the record and the item that we wish to speak to, and then further instructions will be provided to you to call and join in the video conference. When the chair of the committee polls for interested parties, you'll have to press *6 to unmute yourself. The applicant or agent will then be given the opportunity to briefly explain to the committee the basis of the application and answer any questions that may arise. A maximum of 5 minutes will be provided for a presentation. You'll need to state your full name and address for the record. Any submissions beyond the 5 minutes will be at the discretion of the committee. All delegations must also state their full name and address for the record. A maximum of 5 minutes will be provided for each presentation. All remarks and questions are to be directed to the chair, and any submissions beyond the 5 minutes will be at the discretion of the committee. The applicant or agent will then be provided with a further 5 minutes to respond to any comments made by interested parties, answer any questions by committee members. If the applicant or agent has concerns found in staff report, particularly any proposed conditions, this will be the opportunity to advise us. The matter will then be taken to committee for final decision, and this will mark the end of all discussions. Any person desiring a notice of the decision for an application must provide a written request, preferably through the email to the Secretary Treasurer. Written notice of the committee's decision will be mailed no later than 10 days for minor variance and 15 days for consents to the applicant, agent, or any other person who has filed a written request for such notice. Last day to appeal the decision till the Ontario Land Tribunal will be noted on the decision. Only the applicant, specified person, or public bodies may appeal to the committee's decision to the Ontario Land Tribunal. In November of 2022, Bill 23 legislation, the More Homes Built Faster Act, amended the Planning Act to remove appeal rights to members of the public. If no appeal is received within the prescribed timeframe, the decision of the committee becomes final and binding, and the Secretary Treasurer will then notify the applicant and anyone who has received a copy of the decision through written correspondence. People participating in this hearing are to be courteous to, respectful of the members of the committee, town staff, and any other person participating in this electronic hearing. Tonight's electronic hearing is being video recorded and available for future viewing at oakville.ca. Thank you. Okay. We have one regret, Ms. Price. Any declarations of pecuniary interests? Mr. Talowski?
Thank you, Madam Chair. Not a declaration of pecuniary interest, a declaration of a different sort, I guess. Just want to let you know that I'm not doing this to look cool, but I will probably be wearing shades through tonight's meeting as I just recently had cataract surgery and I need to cut down on the glare.
Very well. Thanks, Mr. Talowski. Feel better. All right. Madam Secretary Treasurer, do we have any deferrals or requests for withdrawals of applications? Anyone in the audience who seeks to defer an application, please raise your hand and the Secretary Treasurer will invite you in to speak.
Madam Chair, I see no hands up.
Okay, then we will proceed with the first item on our agenda. Item 6.1, application 138 of 2025 at 402 Bonnie Meadow Road. Again, it's application 138 of 2025 at 402 Bonnie Meadow Road. I have Darren Sanders Smith as the agent. Is Mr. Smith with us?
I am, Madam Chair. Sorry, I was switching over. I wasn't sure what had happened there.
Go ahead.
Thank you. We're here for a minor variance for two zoning issues pertaining to a proposed rear box bay window. I believe this is minor in nature. There was a bay window that was existing there in the original design. Upon construction, we realized that it was rotten, so we decided to replace it with a box bay window. The box bay window went down to the floor as the bay window didn't, and that therefore increased our floor area and required a variance. I believe this is minor. It's in the rear yard and doesn't create any impact on anything. So I'm open to any comments that the committee might have.
Thank you. Any questions for Mr. Smith at this time, or any items of clarification? All right, I have to switch to gallery view in order for me to see. Any questions? No. No items of clarification. Has anyone called with interest for this application, Madam Secretary Treasurer?
No, Madam Chair, no calls and no one with their hand up.
Very well. We'll take a motion. Go ahead, Mr. Hardcastle.
Thank you, Madam Chair. Having undertaken my site visit, having reviewed the written materials, including the written staff report, and heard the presentation, I am satisfied that the requested variances conform to the four tests of the Act. I will therefore put forward a motion of approval, subject to two conditions, those being that the addition be constructed in general accordance with the submitted site plan dated August 26, 2025, and the elevation drawings dated August 22nd, 2025, that the approval will expire within 2 years of the date of the decision if a building permit has not been issued. And I would note that there were no members of the public present with respect to this matter.
Very well. Thank you, Mr. Hardcastle. Is there a discussion on this recommendation? I see none. All those in support? Okay, the application has been approved, none opposed.
Thank you very much. Have a good evening.
You too. Application 139 of 2025 at 874 Sinclair Road. Again, that's application 139 of 2025 at 874 Sinclair Road. I have Mr. Cronus and Mr. Kahar as the agents.
Thank you, Madam Chair. Can you hear me clearly?
Yes, go ahead.
That's great. Thank you so much, and good evening to you and to the members of the committee. I'm counsel for Postscriptum Holdings, Inc. They're the owner of 874 Sinclair Avenue. And what we have in front of you is, in effect, a fairly straightforward minor variance application to permit a motor vehicle dealership use on the subject site, together with ancillary uses or related uses, in an area where motor vehicle dealerships are permitted as of right in the zoning bylaw on pretty much all the lands that surround the subject site. In fact, if you were at the subject site and looked across the street, you'd see a Bud's Jaguar Land Rover dealership that's already operating. If I could just move to the next slide. So you see the subject site there, the dealership, the Bud's dealership's across the street. The site itself is at the northwest intersection of Sinclair Road and Wycroft Road. And its area is roughly 1.4 hectares. Next slide. And I've marked out here all of the dealerships that are in the area. You see the subject property with a star, you see the Jaguar dealership, and you also see in that quadrant a Tesla dealership, as well as a Dodge Jeep Ram dealership. Next slide. That's the building that's on the site right now. It's a roughly 7,800 square meters. The building used to be occupied by the TDL Group Wendy's headquarters and was an office for them several years ago. They relocated, and Postscriptum has had a serious challenge having occupancy of this building and maintaining that occupancy. So really the building is highly underutilized today, but there's been a lot of interest from automotive dealerships to use it, but they're not prepared to take the next step and sign a lease and move this matter forward until they know that the use permission is available for this site as well. So if you could go to the next slide, please. And one more over. Thanks. So that's the existing site plan for the site. And what we envision here is asking for the use of a motor vehicle dealership and related uses to be implemented in the existing building. We're not making any changes to the building at all. We're not making any changes to the site plan. Now, we appreciate once we ultimately get a dealership involved, they may want to do some renovation. That renovation may trigger, if it's a development, site plan approval. And if it's at all necessary, perhaps a variance if some sort of built for standard changes. But today, all we're asking for is the use to be put into the existing building. Next slide. And I note that, you know, staff in their staff report do criticize us for not having plans. And the reason we don't have plans is because we're not changing the building. We're not changing the surrounding area, the area of the site. All we're doing is adding the use in the building that's existing. Now, this slide's important because this is the surrounding area. The subject site is marked in red outline. Other than the subject site in a red outline and the little yellow box you see below it, every other parcel of land permits motor vehicle dealership. It's just these two parcels that were omitted. And I think it has to do with how site-specific zoning was done many, many years ago. I don't think there was any intent not for it not to be here. It was just one of these shrink wrap bylaws that were done for the subject site. Next slide. Now, the subject site itself and much of the surrounding area is designated business employment. Business employment permits in the official plan motor vehicle related uses. There's a prescribed areas. We're in one of those prescribed areas. We are meeting the intent and purpose of the official plan because official plan says for these lands have a motor vehicle use, and that's precisely what we're doing. Next slide. Now, I think where staff are coming from on this is they're saying, look, we need to do an employment study for our employment lands broadly in the city. And we also have this OPA 68. And we want you to wait before we have you implement this use on the site. But I think the reality here is that when you look at what the in-force OP is, and that's what you're required to look at, that permits the use. There's no need for my client to have to wait for some future study. That's not part of the minor variance tests. It is the official plan that's in effect. Next slide. And I've got this slide up simply to articulate that point. And so I'll just ask you to move to the next slide again. And I've cited here some case law, and I can tell you there's been a long line of cases in front of the tribunal that make it clear that when we're applying the minor variance test, the official plan that has to be met, the intent and purpose of, is the in effect official plan. It's not some future study that the town may want to do. It's not even policies that have been, we'll call it, endorsed by council, but not in effect. It's policies that are in effect today. And those in effect policies permit our motor vehicle dealership that we're seeking a permission for. And then the only point I would point to this is that even if policies came down in the future down the road that sought to change what was permitted in the OP, our application would be clergy to that in any event. So it wouldn't matter. Next slide. The other thing that I think staff are concerned about is this concept of areas of employment. And they say the change in the Planning Act that's recently had is such that we can't add now a dealership in an area of employment. And I acknowledge the definitions changed in the Planning Act. It's clearly on the screen, and it's clear that what we're talking about are manufacturing uses now and warehousing uses. We're not talking about retail uses anymore. But the point is, the subject site today is not an area of employment. It is employment lands as that term is understood in the town's official plan. It is not an area of employment as that term is understood in the Planning Act or in the PPS. Why? Because it permits office today. It has had office on the site, and offices are no longer areas of employment. Next slide. Now, there is a saving provision. The saving provision says that if you had one of these uses that wasn't allowed in the area of employment as of October last year, then if you have official plan policy authorizing that lawfully established use, then we can still call it an area of employment. The point here is also very simple. There is no official plan policy today establishing a lawfully established use on the parcel. There is OPA 68, I acknowledge that. It's not in effect. Not an area of employment today. Next slide. This is just the PPS definition of employment areas. I just bring this up because it's the exact same definition as area of employment. Just like we're not an area of employment in the Planning Act, we're not an employment area as that term is defined in the PPS. Why? Because we have office on the site, and office is not part of an employment area. Next slide. So I'm going to just ask you to skip down, just in the interest of time, to slide number 14. Sorry about that. Okay, I see you're moving on. Why don't you skip to slide 18, just to make this simple. Okay, so this is the special provision 3. This is what allows motor vehicle dealerships in the town's zoning bylaw. This special provision 3 has been added to E2 and E3 zones throughout the town. And this is effectively what we're asking for to be added. And you'll see on the next slide that this special provision 3 has been added in a number of instances in E2 zones. And so what I say is, not only does this, because we're designated business employment, which permits motor vehicle in the enforce OP, we meet the intent purpose of the OP. We also meet the intent purpose of the zoning bylaw, because our site, being zoned E2, has many similar E2 sites that have motor vehicle dealership. In fact, if you recall that map I took you to earlier, and we don't need to go there, we've got E2 all around us. And all those E2s have motor vehicle dealership. So it must meet the intent and purpose for that same use to be added to our site as well. And then finally, I will just end off by pointing about the question of whether it's minor and whether the use is desirable for the development of the lands. I would say that we're adding a use in an underutilized building that's going to bring a motor vehicle dealership to this building. That dealership will accommodate somewhere in the neighborhood of 40 to 50 employees. That will advance the economic viability for the town. That's a good thing. It's not going to have any impacts on any of the surrounding lands. Those are all dealerships or motor vehicle related uses anyways. And I think that what the staff concerns are really not applicable for two reasons. One, those concerns are pointing to policy that hasn't even become official plan policy, not part of the test. And second, they seem to be concerned about something called an area of employment in the Planning Act, which doesn't apply here, because this is not an area of employment by the definition in the Planning Act today. So with that, and subject to your questions, those are my submissions in support of the requested variances.
Okay, thank you, Mr. Carr. You mentioned that you didn't have an interested party that really wants this property for dealership purposes as of now. So what's the rush to get that designation?
Sorry, my apologies if that's what I stated. We do have interested parties. What they have told my client is we want the zoning in place. Once we have the zoning in place, we're prepared to take the next step. So it's not that there aren't folks knocking on the door and wanting to do this. It's just that we can't materialize it because we don't have the use and permission in place yet.
Okay, thanks for that clarification. Any questions or items of clarification of Mr. Kehar? Go ahead, Mr. Dickey. You're muted.
Thank you, Madam Chair. Just a few things I'm a little confused about. Let's just go for the first thing. You seem to indicate, you indicated that there are other special provision area 3s which allow dealerships within the E2 areas. And maybe this question isn't fair to be asking you. I could be asking a town planner, but I'll finish off my sentence. I'm wondering if they were all granted at the same time, or were they granted individually? In the examples that you put forth, you had 4 addresses there. I'm assuming each of those were granted individually and went through the process. I'm curious about the E3 areas, for example, across the road at the Land Rover. Did they go through and get that special provision granted individually, or had that all been done in a lump sum with a number of other properties along the Queenie?
It was done in a few different ways through you, Madam Chair. First, some of these sites got their permission when the town did its comprehensive bylaw amendments in conformity with the town's official plan that recognized the motor vehicle use permission here. Others went through specific zoning applications in order to do so. Some had them built right into the actual E zone. So if you were to go back to my slide, and in particular slide 7, you'll see all the colors there. I didn't go through that in detail, but the properties that are E4 had the use built right into it. And that's on page 7 or PDF, if you look at that. Yeah, so the ones that are E4 had the use built right into the zone. The stuff that was E2 and E3 got a cross-reference to that special permission. And there's different ways we got there. That's fair to point out. But in the end, the point is that every parcel of land you see on that screen, other than the subject site and the E2 block that's below it, it was part of that same rezoning, has the motor vehicle use. I really think what happened here is the former Tim Hortons and Wendy's, they got a zoning that allowed their office. It was one of these like shrink wrap type zoning things. And they didn't worry about getting the rest of the permissions that all the surrounding lands got. And I think that's why we ended up in this world where we didn't get the motor vehicle use on this site. But now that we don't have the Tim Hortons there and the office there, and there's a real challenge to putting this building to a use, it makes sense to add it here.
So what I'm having a little bit of confusion. So you're saying that the other properties around you, which now have the permission to have dealerships, went through a site-specific zoning amendment. They did not go through the Committee of Adjustment to get permission to build dealership on their site.
We don't know that, but we don't know that though. If we allow Ms. McKnight to comment on that first.
Oh, okay. Thank you.
Yes, through you, Chair. The site-specific amendments come through a zoning bylaw amendment. So those are brought into the zoning bylaw as zoning bylaw amendments and not minor variances.
But how many of these sites had to go through that process?
Any site that does not have this as an outright permitted use would go through the zoning bylaw amendment process to request this use be brought through a site-specific provision as a permitted use on the property.
Do you know of these properties that are listed, which ones were and which ones were not?
Through you, Madam Chair, any property that was listed, I believe through the presentation that was put on the screen, showed multiple different site-specific provisions. And so those would have all been completed through a zoning bylaw amendment application.
Okay, thank you. Go ahead, Mr. Dickey. I think now you have a better idea of.
Could have. Yeah, I might come back and I'll ask another question. See if anybody else has a question.
Anyone else? Go ahead, Mr. Tarowski.
Thank you, Madam Chair. Mr. Carr, a couple of questions. And I fully understand the argument on the compatibility with the adjacent existing uses. Staff have indicated, setting aside the, or maybe I'll start there, with the OPA under appeal, is your client an appellant or a party to those appeals?
My client isn't today a party to those appeals. But the practical reality is the policy in its entirety is under appeal. And because it's under appeal, there is no in effect policy. And as a consequence, there's no lawfully, we'll call it established uses in each of these, what were formerly areas of employment. So we don't really have areas of employment unless and until those policies come into effect, and we don't know what those policies will ultimately look like post appeal.
And with the enforce OPA, staff have referenced 14.4.3 and 14.4.4, which speak to limited outdoor storage and display. And I think from your presentation, if you're granted the variance and there's no changes to the property, you could effectively put up a Bob's Motors signs and park cars there without needing the site plan approval, perhaps. So is it your submission that without providing site plans to show how you comply with these sections, that your application does comply with these sections when we have no way of knowing what this ultimate site's going to look like? Or if it stays in its current scenario with building behind parking lots, is it your submissions that your application complies with those sections of the enforced official plan?
It is, because our intent is to put the use. So there's two policies that I see staff point to. And our intent is to put the use in the existing building without making any modification to the site plan as it's currently approved. The practical reality is, once we finalize with a dealership, it is acknowledged that there'll be some revision to the building. If that revision triggers site plan approval, we will have to go through a separate process to get approval for any modifications we seek to do. This, if you know, the reality here is that to get to that point, there will need to be further planning approvals. The point here today is simply to get the use permission so we can get that we'll call it dealership on board to take the next step. So I think because we're putting the use in the existing building and not making any change, it conforms to the OP policies.
Thank you.
Madam Chair, you're muted.
Thank you. Any further questions or items of clarification? Okay, go ahead, Mr. Tarowski.
Madam Chair, the applicant has provided a lot of rebuttal to staff report. I just think it'd be fair to ask staff if they'd like to speak to the presentation.
Sure. Ms. McKnight, do you care to comment?
Thank you. Yes, through you, Madam Chair. At the end of the day, planning staff see this through the lens of a zoning bylaw amendment and not a minor variance. That zoning bylaw amendment application would give staff the opportunity to complete a more comprehensive policy conformity and consistency review. We would be able then to review the outdoor storage display, vehicular access, and the official plan policies more in depth. So through a zoning bylaw amendment, there is more latitude to put in place the appropriate regulations to support a change of use. So overall, it really allows for the more comprehensive review of an application that an application of this nature requires.
Okay, Mr. Tulowski.
Thank you, Madam Chair. To Ms. McKnight, is one of the outcomes, is one of the potential outcomes of the study to have this property redesignated that could allow this type of use?
Through you, Madam Chair, that is a potential outcome. This use may very well be permitted on the property at the end of the day. However, it's unknown at this point in time. The study will be going through to Planning and Development Council for a public meeting November 17th. So more information will be provided on that study at that time. And it is looking to be completed in Q1 of next year. So that is coming along, and the emerging policies will be clear in the upcoming months.
Right. Has anyone called with interest for this application, Madam Secretary Treasurer?
No, Madam Chair, there have been no calls and no one has their hand up.
Okay, thank you. All right, let's put the matter to a vote and start the discussion. Who would like to start? Go ahead, Mr. Tulowski.
Thank you, Madam Chair. Madam Chair, the word premature just isn't leaving my mind, unfortunately, in this application. I'm not absolutely convinced you need a rezoning amendment to accomplish what's consistent here with the existing area, but we're in the middle of a town study in reaction to a change in provincial policy and a request for a use that, pardon the pun, can't kick the tires on because we don't have any plans. So we don't really know what the end outcome is of this. I would have much preferred the applicant defer this and try to work this through with staff. They've chosen not to. So, Chair, I just can't find with the information in front of me today that this application meets the Test of Planning Act. With a little more information, perhaps it could have. But with that, Madam Chair, I'm going to move the application be denied. That might generate some discussion. Finding that it doesn't meet the Test of Planning Act, it's not desirable in its current form.
Okay, thank you, Mr. Tulowski. Is there a discussion on this recommendation? Go ahead, Mr. Hardcastle.
Thank you, Madam Chair. I'll keep my comments short and concise. Mr. Tulowski, as normal, has articulated a strong position that that aligns well with my own. I'm struggling with respect to process here. I'm struggling with respect to the tests, desirability for sure, and I'm struggling with the articulation of the test with respect to general intent and purpose of the zoning bylaw. It is clear to me that there was purpose behind the zoning that was put in place here, and this is not consistent with the purpose of the zoning that's applied to these lands. So I would support that motion that's on the floor.
Okay, thank you, Mr. Hardcastle. Any further comments? Okay, I see none. The motion is to deny the application that is before us. All those in support? Okay, and your application has been denied, none opposed. Thank you. Application CAV, no, sorry, application 060 of 2025, deferred from May the 14th at 3071 and 3079 Trafalgar Road. Again, that's application 060 of 2025, deferred from May the 14th at 3071 and 3079 Trafalgar Road. I have Catherine McEwen and Andrew McLeod. As the agents.
Madam Chair, I've moved Catherine McEwen in.
Good evening, Madam Chair and members of committee. My name is Catherine McEwen from Corsiac Urban Planning, here on behalf of the Minto Group. Next slide, please. Subject lands are located on the east side of Trafalgar Road, south of Wheatboom Drive, north of Dundas Street East. Through the review of the draft plan of condominium application, the surveyor's certificate identified a number of parking deficiencies, including, next slide, please. Variances for unit 14 on levels A, B, and C to permit a 2.8 meter width, whereas 2.9 meters is required. Should be noted that only half of the space is impacted. A compact vehicle space for unit 18 due to pipes with a width of 2.6 meters, where 2.9 is required based on the pipes. And visitor parking spaces 16 and 24 on level A, unit 114 on level B, and unit 116 on level C to permit a minimum width of 2.6 meters, where 2.9 meters is required, as well as a 0.3 meter pipe obstruction along the perimeter tongue-tied here, perimeter of the parking garage for parking spaces 21 to 49, 88, 89, and V1 to V20 on level A. This is a gravity-fed servicing pipe that's required to drain down to its outfall. The elevations of the outfall are set by Halton Region's Trafalgar Road trunk sanitary sewer along the west wall and the Athabasca Pond outfall along the east wall for the storm pipe. Our original submission was made back in February of this year, and we made subsequent revisions based on zoning comments back in April. And our original committee of adjustment date was May 14th, which we ended up deferring so we could work with staff to resolve comments and concerns. This included a site visit with town staff in June to demonstrate the location of pipe encroachments and the other impacted spaces with vehicles. Next slide, please. So we kind of demonstrated a variety of different vehicle types that function. We worked with GHD. If you want to go to the next slide. V4 and V5 are the lowest level of the pipe, but we demonstrated that trunks could be opened with a variety of, we did all kinds of vehicle types. Next slide, please. So, like, we demonstrated that these spaces do function. And then next slide. V24 again demonstrates that it's a narrower space, but we could enter and exit vehicles with two vehicles parked beside each other, a Range Rover and we had so many, I don't know what
Looks like
that
a
one
Honda.
is. A Honda. We had a BMW at one point. So GHT, the traffic consultants, they prepared a memo and they justified that they supported the variances and that all the spaces were functional. And then next slide. In consultation with town staff, measures have also been taken to identify pipes with high visibility yellow striping and cushioning. And we're also proposing to add convex mirrors to address staff comments. Next slide. Warning signage will also be added to indicate the location of the pipe, the narrow stalls, and the one compact vehicle parking space. Next slide. So the next three slides indicate where all the impacted spaces are located. The visitor parking spaces will clearly be identified, and none of the resident spaces have been sold. So no purchasers to this date will receive an impacted space without prior written knowledge. That will be, we've talked to town staff about that. We do want to really thank town staff for their continued collaboration and time spent visiting the site in order to come up with proper solutions in this underground parking garage. We've reviewed the staff report and find the conditions to be acceptable and feel that we've met the 4 tests. I thank you for your time. I'd be happy to answer any questions. Also, Andrew McLeod from Minto is also on the line for any questions.
Okay, thank you. Any questions or items of clarification? Mr. Dickey.
Thank you, Madam Chair. I have a few points, and I'll just sort of go at them one at a time, maybe. It seems to be somewhere in the documents that recommended that space number 48A should be for a compact vehicle, but space number V16 also seems to have the same restrictions. Why does that not?
So if you look in GHD's report, space number 48 is restricted because of the pipe. So that's where the concern came from. Like, people, like, want to make sure that no one's going to bump their head getting out of the car and that kind of thing. So that's why that space specifically was identified as a compact space. And I mean, with all the compact vehicles today, and realistically, the people buying a condominium are more likely to have a more compact car than an F-150.
I don't think you answered my question.
Okay,
so V16 is in the variance list for the pipe obstruction. V16. And it is also narrow, 2.6. But you went forth and commented about the compact for number of parking stall 48. I just don't understand why V16 doesn't get the same designation as a compact car space. They seem to have exactly the same parameter dimensions.
I think upon site visit with town staff, their concern was with 48 and not so much 16. Like the pipes are different. So that's why that one wasn't designated as a compact space.
Okay, doesn't help me, but okay, then let's go on to something else. I'm a little bit concerned that you have visitor parking spaces that have the pipes. So if you're a regular tenant or owner or whatever you are living in the building, you would be aware that there's a pipe behind you, or yeah, behind you, basically it's down along the wall. But the visitors are coming in, and I understand you've got lots of yellow tags and everything there, but I'm just like, I'm concerned about that. Why don't you change your visitors parking and pick the other stalls to be visitors parking and give V1 to 20 to the tenants?
So this was a concern with the town, and this was part of the reason that we deferred the application, because we went into the underground parking garage, tested the vehicles, and visitors typically are not backing in. So like, even though we identified that rear trunks and such could be opened if they were backed in, the front in position was not an issue. And that was identified by GHT with their functionality in their report as well.
So you're saying visitors going forwards, not back as a rule?
Typically, that's kind of what came out with our site visit. Even if they did go in rear, we demonstrated that trunks, and most visitors aren't opening their trunks, they're just visiting. They were functional.
I know when I go into a underground parking garage, I like to back in, not for opening my trunk, just so no crook will come along and get into my car from the back. So I like to back my car right up against the wall. Now, maybe some of the others of you are little beepers that beep. I don't know if they beep if you're 2 feet or 2 meters up from the floor. So that's where I'm concerned about a tenant or an occupant would be aware and be used to dealing with the obstruction. The visitor won't be used to dealing with the obstruction. They should be visibly aware, but we know how people don't look. I'm guilty of it myself. You don't look and see stuff. That's where I'm concerned. So the only thing that the planning, and not the only thing, I don't mean it quite like that. The issue that the planning's the parking study person is saying it's all the difference there is that visitors going front face first.
We did demonstrate.
No question, they go at face first. No problem with the pipe. Don't get me wrong there. It's just the backing in that I'm concerned of.
Through you, Madam Chair, we did demonstrate it could be done both ways, and that's why the signage will be posted on all the visitor parking spaces to kind of a warning.
Can you show that signage again?
That is slide number 9.
Okay, yeah, I see it now.
Yeah. So the visitor ones will have like the signage for the pipe. The narrow stalls, the end ones that we spoke about, will have those signs. And then space number 48 will indicate that that is for a compact vehicle.
Okay. Mr. Hassan, did you have anything further to add from the planning perspective?
Through Madam Chair, I'm actually covering for one of our other planners that's away. I was aware and assisted with the review of the application, but unfortunately I didn't attend the site visits. But all of the questions and concerns that Member Dickey had were the concerns of staff from the outset of the application being submitted. just due to the lack of information. But as Catherine had said, the application was deferred to allow on-site meetings with staff to get a better understanding visually and practically for how vehicles could either pull in or reverse in. Unfortunately, although the study says that, we can't control how vehicles operate depending on the driver. All we can do is provide any and all warning and safety measures that we put in place to prevent conflicts with either people bumping into the pipes or parts of the vehicles bumping into the obstructions.
And what's the extent of the damage if someone does open up their trunk and hit one of these pipes? How fortified are they?
They have, through you, Madam Chair, the town has requested that they have extra protection put on them, and they're fortified. And we demonstrated that fortification with town staff, and to a point that they were satisfied. Like the I'll call it cushioning.
Okay. Any other questions? Mr. Dickey, go ahead.
Thank you, Madam Chair. Just two other questions. One question, I'm sure it was said, but are these sewage pipes or stormwater pipes?
They're storm pipes.
Oh, okay.
One's a servicing pipe, and I'll let Andrew. One's a sanitary pipe and one's a servicing pipe.
Oh, one's a sanitary one.
Yeah.
Second question, if I may. The people purchasing condominium apartments in the building, I assume it's not a rental building, it's a condominium building.
That's correct.
Okay, sorry.
And none of these sorry, through you, Madam Chair, none of the spaces that are impacted have been allocated yet. So there's a number of units that are still for sale in the building. So anyone that is going to be assigned to one of these parking spaces with, the impact, they will be fully aware in written notification.
Just
before they purchase.
Exactly. Yeah.
When you use the word assigned, you see they're going to be buying a condominium apartment unit and buying a condominium parking space, or are they just getting assigned a space in the parking garage as opposed to owning it under the condominium?
I'll let Andrew jump in because I'm not sure if they're unitized. I'm not aware of that, but so unitized is when you buy a unit, you get a parking space. But I'm not aware of this one, but there will be full notification.
Well, my thought was somebody might move in and they have a small car and they live there for a number of years and they get a big car, and now their big car doesn't fit comfortably in one of the small spaces. If they're just allocated, and I mean allocated, they're not specifically legally tied to that condominium apartment, then you would think management can deal with that. But if the fellow actually owns the apartment, also owns the parking space, then he's got a kind of an added bit of red tape to solve his problem. Yeah, so nobody knows the answer to that.
Through you, Madam Chair, I don't know if Andrew can hop in on that one.
Is Mr. McLeod on the call?
Madam Chair, I don't have him in the meeting.
Okay, so it doesn't look like he's on with us. I guess it depends on each condominium how they do it. I remember when I had mine, it was assigned, so I sold my condominium with the attached parking spot to it. Oh, I see Mr. McLeod on the phone now.
Yes, Madam Chair. Yes, he's here now on the phone.
Yeah, go ahead, Mr. McLeod. You have to unmute yourself. You press *6. It's *6, right?
Yes, Madam Chair, it is.
Through you, Madam Chair, I just sent him a text, so hopefully he'll.
Yeah,
hopefully.
there might be a glitch. Usually you just have to press *6 and then you're unmuted. We can't unmute you. You have to do it yourself. There are flaws to technology still. Perhaps you can answer the question through text to yourself for the interest of time.
Perfect. So I did, through you, Madam Chair, I just did confirm that parking stalls are allocated at the time of sale. So.
And they are attached to the condominium for the duration that the person owns.
Yes.
That condominium. Yeah. So when they sell it, they will be selling it with that same spot. So then the notification will continue to go down the chains as the condominium gets sold.
That's
to
correct.
Different parties. Okay. Does that answer your question, Mr. Dickey?
Yes, thank you very much. Sorry for that problem delays.
Through you, Madam Chair. So the second buyer, third buyer, they have to see the spot before they buy the unit. Like they would know what they're buying.
Perfect. Okay. Go ahead, Mr. Tarowski.
Thank you, Madam Chair. I understand that if you accounted for every eventuality in design, we would be overbuilding everything to the nth degree. I also understand that you can only warn people so much, but you know, Mr. Dickey does raise an interesting point, and I guess I'm wondering if the committee were to find favor with this application. Would you oppose a additional condition which, is required that the pipe encumbered spaces also be painted with a fourth sign? And I'm thinking a do not back in sign painted on the ground at the start of the parking space.
I don't see that we would be opposed to that. Yeah. The signage is, through you, Madam Chair, the signage is draft at the moment, just as we were working through with staff. So if the committee wanted additional language, that would be fine, I think.
Thank you.
And through you again, Madam Chair, if people are going to do it or not, we'll never know, but.
Yeah. But then, yeah.
At least they're warned.
Sure.
Through you, Madam Chair, all I can offer is that would be a good suggestion. From personal experience, I'm not sure for folks that have been to Montreal, there are small parking garages there that identify that it's not suitable to pull in certain directions or to have certain size vehicles. So it's not uncommon to have that type of signage in parking areas that are very tight and restrictive. So from a staff perspective, I'd be okay with Member Tulowski's suggestion there. And as Ms. McEwen said, that the signage is draft right now and the condo's been draft approved. So it is a condition of the condominium to have all that finalized.
Okay. So, if there's no further questions or anyone waiting online to speak to this application, we'll take the matter into committee.
Madam Chair, I do have a hand up. It's Andrew McLeod.
Oh, okay.
I'll move him into the meeting. One moment.
Go ahead, Mr. McLeod.
Hi, good evening. Can you hear me okay?
Yeah.
Awesome. Thank you. I have been trying to chat for a while, but I was able to text with Catherine. I apologize for the audio issues, but I think Catherine did a great job at explaining the item, but I'm offering myself to committee through you, Chair, to answer any additional questions that there may be in the context of the painting on the ground of do not reverse or do not back in. We have no problem doing that as an additional safety measure, and would be happy to agree to that condition this evening.
Okay, thank you. If there's nothing further, okay, we'll take the matter into committee. Who would like to move a motion? Go ahead, Mr. Tawalski.
Thank you, Madam Chair. Madam Chair, I'm going to move this application be approved as applied for, finding that it meets the test of the Planning Act. With the dialogue we've heard today and the cooperation between the applicant and staff, I do not believe this variance is going to have an adverse impact. I would note that there's no members of the community speaking against this. Also, I guess relevant to the situation is that none of these spaces in question have been sold to occupants at this point in time. And I would make that approval subject to 4 conditions. The 3 submitted by staff, that planning spaces be permitted in general accordance with the planning rationale submitted by Corsiac Urban Planning dated September 12th. Transportation letter submitted by GHD dated September 12th. And registered plan of condominium 24 CDM 24009 1312. That parking space 48 be designated for compact vehicle parking only. That signage be installed with respect to the following 4 cautions: watch for overhead clearance, reduce side yard clearance, compact vehicle space, and do not back in, all to the satisfaction of Director of Planning and Development, and that the approval expires 2 years if a building permit's not been issued.
Very well, thank you, Mr. Tawalski. Is there a discussion on this recommendation? Okay, I see none. All those in support? Okay, the application has been approved, none opposed. Thank you.
Thank you.
Thank you.
Application 099 of 2025, deferred from July the 23rd at 248 Jennings Crescent. Again, that's application 99 of 2025, deferred from July the 23rd at 248 Jennings Crescent. I have Christine Dang as the agent.
Good evening. Can you hear me?
Yes, go ahead.
Hi, my name is Christine Dan, the agent of 248 Jennings Crescent. My contact address is 2710 14th Avenue, City of Markham. The proposal is for a 2-story single detached dwelling. This application was previously deferred on July 23rd, 2025. The application before you today seek relief from the zoning bylaw for only one variance, which is the residential floor area ratio. We have consulted extensively with the planning staff regarding this application and have made a number of revisions to the proposal to satisfies planning staff. And this is the proposal in front of you today and also reflected on the staff report. The permitted RFA is 41%. The original proposed RFA was 44%. The revised RFA is 43.78%. This represents an increase of 20 square meters over the permitted maximum. In the last planning report, one of the main concerns was the two-story window elements facing the street. If you look at the slide, the image on the left shows the original front elevation, and the image on the right shows the revised version. We have broken up the two-story window into separate elements and stepped back the second floor wall by 2 feet. This was done to mitigate any perceived massing or scale impact on the streetscape and to better fit in the character of the surrounding area. Next slide, please. This slide compares the original and revised floor plans. The red area shows where floor area has been reduced. Planning also raised concerns about the two open to below areas, which are marked in blue. In response, we have removed the larger one at the rear, keeping only the front open to below, which is about 5.69 square meters. We have also removed both the front and rear second floor balconies as suggested by the planning staff. Next slide, please. We also found some approved RFA variances in the surrounding area. The highest approved RFA was 45.22%. The average approved RFA was 43.81%, which is higher than what we are proposing today. So we don't have building setbacks or height variances, and there is no objection from the surrounding neighbor or planning staff. So we have no issue with the recommended condition in the staff report and believe our proposal is minor in nature. Thank you for your time, and I will be happy to answer any questions committee may have.
Okay, thank you, Ms. Christine. Any questions or items of clarification? Okay, I see none. Has anyone called with interest for this application, Madam Secretary Treasurer?
No, Madam Chair, there have been no calls and no one has their hand up.
Very well. Let's take the matter into committee. Who would like to move a motion? Go ahead, Mr. Dickey.
Thank you, Madam Chair. So based upon my review of the owner's application, the site plans and building elevations, my site visit, and together with the presentation by the owner's consultant and the planning staff's report, I am satisfied that the variance is minor in nature and conforms to the 4 tests under the Planning Act, and I put forth a motion that the application as applied for be approved, subject to the conditions that the dwelling be constructed in general accordance with the submitted site plan and elevation drawings, revision 1, dated, I guess that's June 2nd, 2025, and that the approval expires 2 years from the date of the decision if a building permit has not been issued for the proposed construction.
Okay, thank you, Mr. Dickey. Any discussion on this recommendation? See none. All those in support? Okay, the application has been approved, none opposed.
Thank you.
Thank you. Have a good night.
You too.
Application 122 deferred from September the 3rd at 2087 Wakely Street. Again, that's application 122 deferred from September 3rd at 2087 Wakely Street. I have Mr. Van Kulen as the agent.
Good evening, Madam Chair, members of the committee. My name is Curtis Van Kulen of Hughes Design Studio.
Go ahead, Mr. Van Kulen.
Yes, I'm representing the owners of 2087 Wakely Street. file number A122-2025. We're here before you after working with town staff to reduce a number of variances as well as eliminate 2 variances. So we reduced, we eliminated the residential floor area and the height variance that we originally came in with through careful consultation with the town staff. We're here before you with the remaining 3 variances, 2 of which, the garage floor area and the lot coverage, we feel are definitely minor in nature. The garage floor area basically restricts the size of the garage in the zoning bylaw in order to not have that as being a main part of the massing. So we've kept our design to attribute that mostly to the rear of the garage, and the front facing portion of the garage is mostly facing the street as a 2-car garage. The lot coverage is mostly attributed to the front and rear covered porches, which are single story. The main front entry porch was reduced from the original design so that town staff was more amenable to the actual height and massing of the front entrance feature. The main variance I wanted to speak to was the front yard setback, which was slightly reduced just because we played with the position of the house slightly to eliminate some massing concerns on the left side of the proposed dwelling. So the front yard setback, if staff would like to go to the first page of the submitted, the second page of the submitted document, there's a figure below the drawings. There's a figure in there that I wanted to show in the letter that was submitted along with the drawings. Should be below all of the drawings. If you scroll down in that document, the submitted materials included a letter. If you keep scrolling below all of the architectural drawings, there would be a letter. Next, sorry. That figure there shows the position of the dwelling. And due to the shape of the street, the front yard setback is really pinched on the left side of the property there. So we've worked on this diagram to demonstrate the massing of the house. Even though we are seeking relief from a front yard setback, we are still actually behind some of the massing, most of the massing on the street in terms of those 2 neighboring properties. It's just because of the way that the lot fabric in that area sort of curves up and around and really kind of creates a bit of a pinch point there. Visually from the actual asphalt, however, the asphalt itself of the street doesn't curve quite as much as the lot line. So the front yard presents a lot more than the actual dimension that you see there. We've obtained 15 letters of no objections from the surrounding neighborhood. So we have quite a bit of support in the area. We do feel that the remaining 3 variances that we are seeking are minor in nature and meet the 4 tests. And with that, I submit it back to you for any questions you might have. Thank you.
Thank you, Mr. Van Keulen. Any questions, items of clarification? Has anyone called with interest for this application, Madam Secretary Treasurer?
Madam Chair, there have been no calls and no one has their hand up.
Okay. All right. So let's move the application to the, to have a motion. Go ahead, Mr. Hardcastle.
Thank you, Madam Chair. Having undertaken my site visit and having reviewed the materials, including the written staff report, and having heard the presentation from the applicant, I'm satisfied that the requested variances conform to the 4 tests of the Act. I'll put forward a motion of approval. The motion will be subject to conditions, those being that the dwelling be constructed in general accordance with the submitted site plan and elevation drawings dated September 15th, 2025, and that the approval will expire in 2 years of the date of the decision if a permit has not been issued. I would note that there were no deputations by members of the public with respect to this matter.
Very well, thank you. Any discussion on this recommendation? I see none. All those in support? Okay, the application has been approved, none opposed.
Thank you. Have a good night, everyone.
You as well. We have minutes to confirm for October the 2nd. Thank you, Mr. Hardcastle. And a motion to adjourn. Thank you, Mr. Hardcastle. We are adjourned at 8:15.